Hello, Facebook Live. My name is Jesse Nolan. I am the Director of Membership and Marketing at the Jazz Education Network, and we're delighted to have you here today for a very special session called Copyright 101 for Music Educators. I have with me a good friend and colleague and also a member of the Jazz Education Network, Mr. L. Kevin Levine, which I think you can see him on your screen. Hey, Kevin, how you doing?
How y'all doing?
Awesome. And we're going to jump right in and let Kevin get started here. We took a lot of amazing questions in from our registrants before the session, so we're definitely going to make some time to get to those. Please, if you have questions as we go, drop them in the comment stream. I do want to mention that we are running a membership promo. It's a join now, pay later promo, or if you are already a member, you can renew now or upgrade now and pay later. If you are not a member, you can use the promo code JOIN20NOW. We will also send this out after this webinar. And if you are a member who is returning and renewing, you can use the promo code RENEW20NOW, all one word, and you will be able to join now and pay later. And that code is good through December 15th. Please head over to our website, jazzednet.org, to check out some of our other webinars and sessions that we've already done. But right now, let's get to the topic of the day. I'm going to turn it over to Kevin, and we're going to talk about Copyright 101 for music educators. Kevin.
Great. Thank you, Jesse. Well, delighted to be able to speak with you guys today about a topic very near and dear to my heart, and something I've been really blessed to be able to incorporate into my day-to-day practice. So before we get started with it, I will give you just a very, very brief background on myself. I'm a lifelong musician. I've been playing drums since I was a little kid. Literally grew up in a music store and just naturally gravitated toward drums as at least a second generation drummer. I received my BBA in marketing from Marshall University in 1993, went back and got my MBA also from Marshall. Received my Juris Doctorate from West Virginia University, and also have a specialist certificate in music business from the Berklee School of Music Extension School. Since 2013, I've practiced in Nashville. I've had my own firm, L. Kevin Levine PLLC, where based in Nashville, obviously I do a lot of music law. I do a lot of other areas of entertainment, representing everyone from producers, literary authors, visual authors, television producers and screenwriters, and a pretty good swath of folks in the entertainment world. And then also, I am a trademark geek. I will admit that. I have a thriving practice in trademark as well, where I represent a number of individuals and companies in helping to select, protect, and exploit, which exploitation is a beautiful word in intellectual property, their trademarks. So also serve as an adjunct instructor at Marshall University, where Jesse and I first met, as a matter of fact, in the College of Business, as well as in the College of Music, where I teach music business and entrepreneurship. So just to start off, of course, what would a lecture with a lawyer be if you didn't have just a few disclaimers? So we'll go through those. We're going to cover, or at least attempt to cover, a lot of material. It's a rather ambitious agenda that I have. I know that some of you have already sent questions in, and that's great. We will try to answer as many of those as we can at the end. But understand that today we're talking about just kind of a broad overview. Legal issues, it's important to understand, they are rarely uniform, and they should always be evaluated with legal counsel of one's choosing. And understand that just because I am a lawyer, I am not your lawyer. Okay, so no attorney-client relationship is created by you participating in this. So with all that out of the way, let's go ahead and just jump right into it and talk about what in the world a copyright even is. Okay. Now, interestingly enough, if you were to go and for you insomniacs out there, I certainly invite you to do this. If you were to go and look at federal the Copyright Act, you'd really have a hard time finding a set definition of copyright. You would really have to kind of put together, a definition based upon the rights. So I always defer to looking at Black's Law Dictionary as the kind of the definition, the best definition of copyright. Copyright at its core is a property right, okay, and it's important to realize that it's not something that's tangible like your car or your house, but it gives you the same rights as if it were a piece of real property like a house, or a piece of personal property like a car or a laptop or whatever. It is a true property right in an original, obviously the underlined words on this slide are underlined for a reason, in an original work of authorship. When we talk about works of authorship, we are talking about creative works, literary works, musical works, artistic works, photographic works, film works, sound recordings, those types of things. We're not talking about inventions. We'll talk about distinguishing that maybe in a little bit, or maybe in a different session, distinguishing different types of intellectual property. But it's fixed in a tangible medium of expression. That's important as well. You can't form a copyright in your head. You have to actually put it down to perfect that copyright. And it gives the holder of that copyright, usually it's the author, but whoever it is that holds the ownership, the exclusive right to reproduce, to adapt, to distribute, perform, and display the work. Okay, I know that's a rather long, convoluted definition. We're going to actually break down some of those elements here over the next slide or two. The first thing I want to talk about is this idea of tangibility. When we are looking at tangible, or the definition we just talked about, it's important that the work has to be captured in a tangible medium of expression. Tangibility, just being frank, years ago, when we didn't have as many different types of media, figuring out if something was expressed in a tangible medium of expression was a little easier than it is now. Many things can be, can meet that definition of tangibility today. But essentially, when we talk about tangibility, we mean something that can be perceived, reproduced, or otherwise communicated, either directly or with the aid of a device or machine. So, the picture that I have here, of a vinyl record, certainly that, is a tangible medium. We can't hold the record up to our ear and hear it, okay? It's something that is we can perceive by using the aid of a machine or device, in this case, a turntable and, a stereo system. So, in addition to a device or something that will allow us to hear sound recordings, the written notation itself, of the underlying musical composition, which we'll talk about in more detail later, that in and of itself, meets the definition of tangibility. Likewise, work tapes. If you are a songwriter and you sit down and you come up with a new musical composition and you record that into a tape recorder, or these days into your iPhone or smartphone, that's what we generally call a work tape. Guess what? That also meets the definition of tangibility. Really, and electronic files as well. It should go without saying that in 2020, there are a lot of things that meet that definition of tangibility. So I want to talk briefly about the origin of copyright. Copyright is one of those things that depending on what your angle is, you either really love copyright or you think that it's something that is abused. And copyright really has a fascinating history, and we won't go into much of it today. But I do want to point out the fact that it goes all the way back to the founding of the country. Essentially, the Constitution, Article 1, Section 8, Clause 8, is commonly referred to as the Copyright Clause. And this is basically the language. Our founding fathers realized that copyright and was an important element for a fledgling country. So we have basically the Copyright Clause, which this again is it. The Congress shall have power to promote the progress of science and useful arts by securing for limited times is important, to authors and inventors the exclusive right to their respective writings and discoveries. So essentially, the founders, again, they recognized that this is a new country. I mean, it's an experiment. So in order for it to, take off, we actually had to incentivize industry. We had to incentivize the creation of cultural works. These are things that any developed society needs. So basically, the copyright clause is sort of a trade-off. It provides Congress with the power. Again, this is not the actual law. This is what provides Congress with the authority to create, to regulate that area. But it provides a mechanism for Congress to incentivize creation and invention. Okay, so essentially, copyright law, and we don't have time to spend today because we're covering so many things on a lot of the historical aspects. But understand that copyright at its root, really copyright and intellectual property law generally, is there primarily to benefit the public, not the author or the owner. Again, I mentioned that these are for limited times. The fact that it's limited means that at a certain point, those works will fall into the public domain and they will be available for anyone to use. So a lot of times people look at copyright kind of backwards. And again, they think, well, it's just a way for people to make a lot of money. And don't get me wrong, I'm not going to sugarcoat it. Certain copyrights make a lot of money. But the bottom line is the underlying policy reason for copyright is really to benefit the public, not necessarily the author or the owner. That limited monopoly is a trade-off. We'll let you make money for so long, and then ultimately the public is going to be able to use it. So a question that comes up very, very frequently in my practice, and I'm sure in a lot of folks' practice, is when does copyright begin? Copyright is one of those areas that's kind of hard to nail down sometimes when a copyright actually is born, so to speak. And copyright, the best way to look at it is copyright subsists in that original tangible or an original work of authorship, at the moment that it is captured, the moment that it is fixed in that tangible medium of expression that we talked about. Okay, as soon as an author captures an original work in that medium of expression, that author owns that copyright, that work. Okay, assuming that author doesn't have a contract with a music publisher or somewhere where it's deemed it's deemed the property of the principal. But assuming that type of situation isn't isn't in the scenario, then whoever it is or when someone captures it, they own the copyright. If I ask you all, hold on for a second, I just had a brainstorm. I'm going to turn over here and jot down, the first verse and chorus of a new song. I own that copyright. Okay, I own the copyright in at least what I captured at this time. Now, I may come back later and write a second verse. I will have captured that portion at that time. So copyright begins the second that it's fixed. Okay, registration is a different issue. Okay, one way that I found kind of easy makes it easy to understand this concept is understand that copyright in a pure form is a noun. Copyright is a noun. It's not a verb. Very frequently, clients will contact me and they'll say, hey, I have a catalog of songs and I need some help copywriting those. I generally ask, well, do you have them, either written down in notation form? Do you have work tapes? How have you captured them? Yeah, I have made demo recordings of all of them. And the truth is, they have already created the copyright. Okay. Usually when people talk about, quote, copywriting a work, what they really are talking about is registering that work. Okay. It's essentially registering the registration of a claim to a copyright that the claimant already owns. If you think about, old Western movies, and particularly, you have the old gold mine, the prospector on there who has staked his claim. It's kind of the same thing. The moment that you create that work, capture it in a tangible medium of expression, you have staked your claim in that. The registration of that claim is a different issue. That would be, the equivalent of that prospector going down to some government office, filing a paper and saying, hey, I own this mine. Okay, it's the same basic concept. Okay, just in a different area, obviously. So it's important to understand that copyright registration is not the same as copyright creation. Okay, so copyright registration in the U.S. at least, the federal registration is not mandatory to establish ownership. Okay, if I write a song today and Jesse hears it and he says, wow, that's a great song. And I know Jesse long enough to know that he wouldn't do this, but let's assume that he, for the sake of argument, that he decides to record it and put it out without, securing a license from me. Well, I still own that copyright. I can't sue Jesse for copyright infringement until I have secured a copyright registration. Copyright registration is a jurisdictional requirement to sue for copyright infringement in federal court. Now, change it up a little bit. If I write that song today, Jesse hears it and says, Kevin, I'd love to put that out on my next album. I can do a lot of different things. I can license it to Jesse. I don't have to wait till I register it. I can issue him a mechanical license, while the ink's still wet on the song. And, I can collect a licensing fee from him. I can do a lot of different things with that, but I can't sue for infringement. Okay. So it's important to understand that. Kind of the flip side of that is anyone who claims copyright in a work can affix a copyright notice immediately. Again, you don't have to wait for some magic piece of paper from the federal government back. This is what I have here. This is a typical copyright notice that you would see. A circle C or the word copyright, sometimes COPR, period, the date in which it was first published, the name of the copyright claimant, and that's pretty much all that's required. Now, all rights reserved is language that we generally put in just to kind of cover ourselves. I won't go into too much detail on that. It's not necessarily required, particularly under U.S. law, but in some other jurisdictions, it's necessary. So we lawyers, being warriors, we typically advise our clients go ahead and put it in there, and it really does clarify and put the world on notice that yes, I'm claiming all rights in this work. So I want to kind of go back to a concept that we've talked about a couple times here, and it's this concept of an original expression of an idea. Okay. No one can own an idea. Now, I know that sounds kind of silly. Okay, if I spend a lot of time, maybe I'll hold myself up in my office for 3 days writing the perfect song in my head. Okay, I actually take that back. Say I hold myself up for 3 days and I think, man, I got to come up with a song. What am I going to write about? Okay, I'm going to write a song about a boy who meets a girl. The girl's going to break the boy's heart. What do I own? I own nothing. Okay, all I've done is come up with this general idea. I haven't put in any type of detail. I haven't created an original expression of that idea. In order for there to be a copyright, or at least a protectable copyright, there has to be some degree of creativity, and it does not take much, but it does require some creativity. So the idea of boy meets girl, girl breaks boy's heart, and vice versa, that's the non-protected underlying idea on which countless films, books, TV shows, songs, are based, and nobody owns that idea. Okay, the idea itself is just outright for the picking. We'll look at that. We're going to dig a little deeper into this concept on the next slide. So just kind of hold on to that thought for a second. Titles as well, whether it's a title of a movie, a title of a of a show, of a song, whatever. Titles are generally not going to be protectable under copyright. Truly, I'm not aware of any circumstance in which a court has held any title to rise to that level of creativity to be protected under copyright. But trademark, some other common law claim or theory might work. So generally speaking, titles may be protectable under some other legal theory. So, just as for instance, if you are an aspiring screenwriter and you're going to write, a screenplay set in a galaxy far, far away, I would not call it Star Wars. Okay, you're not going to be sued under copyright for stealing the title. But you certainly will be sued under trademark, under unfair competition, some type of misappropriation of goodwill, and umpteen under other claims as well. So understand that in many cases, just the idea of what area of law protects an area is not always clear cut, and those are not always mutually exclusive. Okay. So I want to go back and talk in a little more detail about the idea versus expression. And we really have in copyright law what is most of us call the idea expression dichotomy. Okay, and I'm going to kind of give you just an example here to hopefully solidify the distinction. Again, ideas, a raw idea is not protectable. So if we have a situation where boy meets girl, they fall in love, they get married, and they live happily ever after with sunshine, lollipops, and unicorns. That is not protectable. Okay, if I sat here and really put my mind to it, I could probably rattle off half a dozen copyrights that are based on that general idea. But if we turn it around and look at an expression that's based on that general idea, say the boy's named Eddie, say the girl's named Brenda, say they met in an Italian restaurant, for all my Billy Joel fan friends out there, say it was hate at first sight, it turned to love, they broke up, they reunited several times, we have this back and forth romance. That they decide to get married. Eddie shows up at the wrong church, and it's just a mess. But ultimately, everything works out. They end up having 10 kids, 50 grandkids. They end up getting wealthy, et cetera, et cetera, et cetera. All these different things. We are sprinkling in all these details, and at a certain point, it's going to move from a non-protected idea to a protectable original expression of that idea. Okay. Now, where that happens, it is generally determined, in many cases in a courtroom under an infringement lawsuit surrounding. But the bottom line is, at a certain point, when we sprinkle enough detail in, it's going to change from a general raw idea that's not protectable into this protectable expression of an idea. Okay. So we're going to shift gears here a little bit and talk about what it is that you get, by owning a copyright. So if any of you have any experience with real property, if you own real estate, or if you've ever had any investment property, or if you have experience maybe as a real estate agent or broker, you've probably heard of the bundle of rights before. Okay, there are in the real property world, there are certain rights that go along with the purchase of a piece of property in what we call fee simple. You obtain all of the rights. The similarities are really pretty astounding when you look at the bundle of rights in real property and what we call the bundle of rights in it's certain intellectual property, certainly in copyright here. So we have really what we a whole bundle of rights, and if you think of them as sticks, and these are really bad-looking sticks, assume that this is a group of sticks here. These are the rights that we get that are provided under Section 106 of the 1976 Copyright Act. Some of these apply to, or some of these rights apply to all types of copyrightable works. Others apply only to certain types. But basically, we have the right of reproduction, the right to prepare derivative works. For certain types of work, including musical work, which is, of course, important to us today, we also have the right to perform and the right to display the work. Okay, so reproduction, that's kind of when you think about what is it that I can do if I own a copyright, well, I can control how many copies are made. I mean, when you think about the word copyright, it kind of goes hand in hand. So when we talk about the reproduction right, it is kind of the granddaddy, so to speak, of all of the bundle of rights. When you talk about kind of going down the list here, the derivative use right here, that's the right to create additional works based on our underlying work. So going back to what I mentioned about Star Wars a few minutes ago, and I'm a child of the 70s, so I still think of them in the original order. We had Star Wars, we had Empire Strikes Back, and we had Return of the Jedi. But for the fact that the original Star Wars was created, we couldn't have had that derivative work. So that, applies to all types of works, all types of copyright works. We also have the distribution right. The person who owns, or the company that owns that copyright, can control how it is distributed and disseminated to the public. Okay. Now, for musical and certain other types of works, which we won't get into for today, we also have this performance right, and we have a display right. Most of you, I'm sure, are familiar, at least in the United States, with performance rights organizations, BMI, ASCAP, and SESAC, and there are obviously international or PROs in other countries as well. But when we look at that performance right is what's being administered by a PRO. When you hear music being performed in a live atmosphere, it's implicating that performance right. And the PROs are licensing and collecting revenue from that. Okay. So the interesting thing about the bundle of rights is each of these rights can be, divvied up, can be licensed independently, can be exploited independently as well. So it's not a situation where, it's an all or nothing thing. Very often you'll have, a copyright owner that will have, multiple licenses out there to different parties, for the reproduction right and the distribution right, but yet they're retaining that derivative use right. And so they can all be, exploited independently and really in a way that makes the most financial sense for any particular work. So let's shift gears and talk a little bit about what I would call, music industry specific copyrights, okay, or at least copyrights in the context of the music industry. There are really two primary types of copyrights that kind of fall into this area, or at least the ones that we deal with on a regular basis in this industry. The musical composition, okay? The musical composition, and it's kind of a chicken or the egg scenario. The musical composition essentially has to come first, and I'll hopefully solidify that idea here in just a second. The musical composition is the underlying musical elements. It's the notes, the melodic structure, the lyrics, basically everything that makes that particular song that song. Okay, if you go to 5 different football games, over a weekend, you're going to hear 5 different versions of the Star Spangled Banner. But you're going to know, if someone says, "Hey, what song is that?" You're going to know it's the Star Spangled Banner. Why? Because I know the underlying song. Okay, I might be hearing 5 different arrangements of it, but as far as the musical composition, it's the same one. Okay, that musical composition, again, it's kind of the chicken or the egg. And I used to belong and be affiliated with Nashville Songwriters Association International as a chapter coordinator. Great organization that really does a lot for not only professional songwriters, but also just the preservation and the enhancement of copyright in the U.S. But their international slogan is, "It all begins with a song." And I love that slogan, because if you think about it logically, you can't have a recording unless you have that underlying song. Okay, if I'm in a band and I decide, I think we're going to put out an LP next year. We can't just show up, book a studio, show up, and then bang, hey, we recorded. What do we have to do? We actually have, before that, we have to know what song, we have to actually have songs, and we have to come into the studio with those songs. We don't just show up and it just happens instantaneously. So the musical composition has to come first. Secondly, we have the sound recording. And the sound recording is a particular recording, or a recording of a particular performance of that underlying musical composition that we talked about in the previous slide. Sound recordings can be called a number of different things. Sometimes they're called masters, sometimes they're called master recordings, sometimes they're just called recordings, sometimes they're called sides. We're always talking about the sound recording copyright whenever we use any of those words, but it's the actual recording of a particular performance. It's not the music. Okay, and this is one area that I sadly have seen folks really end up screwing themselves up on their careers, where they don't understand what the word music means in an agreement versus what the word master or recording or sound recording means. And it's important to understand those are 2 different copyrights. Okay. Don't confuse the physical phono record, which contains the sound recording. In this case here, the CD with the actual sound recording. We can't actually see the sound recording. It's intangible. It's intellectual property. Okay. The only thing we can see is the physical copy. And embedded on that physical copy are the notes, the lyrics, all these things that make that sound recording. Okay. So based on this slide and the previous slide, we now know that if you turn on your radio and you hear a recording, you're actually listening to at least 2 different copyrights. First of all, you're listening to that underlying musical composition of whatever the recording is you're hearing, and you're listening to the sound recording of a performance of that underlying musical composition. Okay, so, and in every instance, we could talk about this issue or this concept at length. We don't really have time to do that today. But this is the reason that when you look at the bundle of rights, certain rights apply to certain types of copyrights, others don't. At the risk of confusing the issue, I will go ahead and mention that there is a reason that BMI and ASCAP and CSAC in the U.S. don't collect anything for the sound recording rights owner. And that's because if you remember back on that slide, there is no public performance right for sound recordings in the U.S., only for musical compositions. Okay. Now there is a little bit of a tweak, but it's a distinction for digital distribution only. Again, that's something that I don't want to go down that road because it'll take us into territory that we really don't have time to cover. But there is a performance right for digital for a sound recording in the digital distribution realm. So what I want to do now is kind of give you a little example here and hopefully nail down both of these concepts, the concept of sound recording copyrights and the underlying musical composition copyright. I always like to use Hey Jude as an example because everyone knows the song and it's been recorded a lot of times, okay? So just to kind of look at taking those previous two slides out and giving you, hopefully a solid example. Again, Paul McCartney thought of the idea for Hey Jules. Okay, eventually it turned into Hey Jude. But just imagine he starts writing the song in his head. What do we have to have a copyright? One of the things, remember, we have to have something in a tangible medium of expression. There's no copyright at this point. It's all in Paul McCartney's head. Fast forward, and Lennon and McCartney pen the first version, or pen the musical composition, and they jot it down, medium of expression. But remember, it all begins with the song. The sound or the musical composition is created at this time. Fast forward again, the Beatles go in the studio and record a particular performance. At this point, the first sound recording copyright is created. If we go forward, you will see that Hey Jude has been recorded by many, many other artists. There have been a lot of different versions, everyone from Wilson Pickett to the Temptations to Woody Herman, Stan Kenton. A lot of different versions of Hey Jude exist. So each time a new version was recorded and a new sound recording copyright was created. So today, if we look at kind of the landscape, there is still only one Hey Jude musical composition that underlies all those different recordings. But there are many, many different sound recordings of Hey Jude. Each is a separate copyright. For the most part, they're going to have different owners. They're going to be subject to different licenses. Some may have appeared in film, some may not. There are a lot of different issues, but each can be exploited separately, and it's just important to understand. We still have one, musical composition of the Hey Jude, but many, many different sound recordings. Okay. We're kind of in the home stretch here because I want to make sure we have time for questions and answers. And I want to talk a little bit about fair use because this is an issue that obviously comes up a lot in the classroom environment. And unfortunately, fair use is one of those areas that can be confusing. Unfortunately, a lot of times fair use gets kind of trotted out without a firm grasp on what it means. As a general proposition, and I always cringe whenever I show this to folks, but I'm going to throw it out there. This is actually from the preamble to 17 U.S.C. Section 107. Section 107 is known as the Fair Use Statute. This comes straight out of the preamble. A use, and again, we're talking a use of a copyrighted work, is non-infringing if it is, quote, for purposes such as criticism, comment, news reporting, teaching, and these words are included there, parentheses, including multiple copies for classroom use, scholarship, or research. The issue that you run into is many times educators will read that preamble, and it is truly a preamble. I'm not going to bore you by showing you the whole statute here because it is a bit voluminous, but it's a preamble. It basically says it's important to look at the words such as. Okay, that doesn't mean that those are all going to be included. It also doesn't necessarily mean that what an educator or anyone deems in his or her head as meaning one of these things is actually what happens. There are situations where where people have used works in a teaching environment, within the four walls of a classroom, back when Classrooms actually had 4 walls instead of a lot of screens, and they were banking on fair use to apply, and lo and behold, it didn't. Okay, it's important to understand that not everything that happens in a classroom is fair use per se. Okay. It's actually something that has to be determined on a case-by-case basis. Fair use, just as a legal doctrine, it's an equitable rule. Okay, when we look at equitable rules, we're talking about rules that are created out of fairness. Okay, truth be known, fair use is more accurately described as an affirmative defense. Okay. Affirmative defenses come up generally in one context. That is, after you have been sued for infringement, you assert an affirmative defense of fair use to say, well, yeah, I was using this without a license, but it's a fair use. Okay. The bottom line is it's not a fair use unless a court tells you it's a fair use. And again, courts are at least supposed to consider each particular situation independently. And in doing so, there are 4 fair use factors that courts are at least supposed to apply. The first of these is the purpose and character of the use. Okay, and that includes courts looking at whether or not the use is for commercial or nonprofit use, or educational use. What was the reason it was used? Generally speaking, and this should come as no surprise, if it's being used in a commercial way, generally speaking, someone using a copyright in a commercial way, if they're making money off of it, that should receive less leeway than an educational use or some other use like news reporting, commentary, some other non-profit based use. Courts also, we could spend a lot of time on this, but we won't, but courts will also look at, if the use is what we call transformative in nature. Has the new work transformed that previously existing work into something different for a different purpose? If it's being used transformatively, most courts, they're going to look at that transformative use as saying, okay, they're not using an exact duplicate. They have transformed it into this new use, so it will get a little bit of leeway. Secondly, courts are supposed to look at the nature of the work. Okay, and when we talk about nature, we're not talking about different types of works like a sound recording versus a novel. We're talking about, are we looking at a creative work? That, for example, a novel. A novel is very creative, or a book of short stories. That's very creative, versus a less creative work like a technical paper or maybe an instruction manual or something like that. So the nature of that underlying work, courts are supposed to look into. The more creative it is, then the more protection it should get, and the less prone to fair use it should be. The third element is the amount and substantiality of the portion used in relation to the pre-existing copyrighted work as a whole. So really, courts are supposed to consider the amount of the work used, not only quantitatively. In other words, did they use 3/4 of this existing work, but qualitatively as well. And there's a very famous case out there that dealt with a situation where in a book review, the book reviewer basically, gave away the top secret ending that was in the book. Okay. Yeah. A book review in and of itself, it sounds like, well, this is criticism, or maybe news reporting, but probably criticism. It should be fair use. Well, it may have been had you not ruined, gone to the top secret part of the book and made that available freely to anyone. Okay. So the amount and the substantiality of the portion used is something that's very important. And that last example that I mentioned, it really plays into this last factor as well. The effect of that use upon the potential market or value of that work. So if you had some really juicy details in a biography on someone, and it was revealed in a book review, guess what? The market value for your work just took a significant hit. So the effect of that use, ultimately, it definitely impacted it. So whether the infringing use is going to harm the market for the original work, and not only in terms of direct sales, but sometimes it will also harm the market for maybe licenses. There may have been a situation where this particular work, you anticipated being highly licensed for other uses, and because of this use, well, it totally destroyed the potential, or significantly, harmed the potential for those licenses. So those are the four key functions, or the four key elements that courts will consider. Again, I will encourage you as educators not to get stuck in that preamble language of Section 107, but to read and understand that regardless of whether it sounds like what you're doing is for criticism or teaching, courts ultimately, they will look at all of these elements and determine it. And they really look at all. They don't look at any one in particular. They look at at the amalgamation of all of them. So that is what I have prepared, and I'll go ahead and throw it back to you guys for question and answer. And
thank you, Kevin.
Absolutely.
Hey, so I'm gonna throw some questions at you, some that came in before the session and some that are just coming in now, and they primarily are divided into two buckets along the lines of what you presented earlier, which is they're dealing with the underlying musical composition copyright,
okay,
or they're dealing with the use of a master recording.
Okay.
So yeah, let's dive in. So let's start with the musical composition questions. There are questions about making copies of music for students, of sheet music. So I bought an arrangement, and I want to not distribute my originals. I want to photocopy them, or perhaps I bought an arrangement that only has 4 trumpet parts and I have 8 trumpets. As an educator in the classroom, can I do that? Can I copy that music?
I'm gonna give you a lawyer answer. It depends.
I know. You always give me those answers. I'm ready for them.
And the bottom line is, this potentially falls into a fair use issue. Okay. One of the things I neglected to mention in the fair use is most lawyers, certainly in my circle of friends, I think pretty uniformly hate it when people come to us and ask us fair use questions, because at the end of the day, we know we're just going to upset our clients because we can't give them a straight answer. It may be a fair use, but we can't really tell you. If you get sued, we'll find out together, or words to that effect. The bottom line is, if you are making a copy, okay, without permission to make that copy, that, is it permissible? No. Okay. Does it potentially fall into a fair use? Maybe. Okay. Now, obviously, one of the things that I would hope a court would look at is, or would be developed during a case, is, why did you make the copies? Well, because my students are notorious for losing copies, and then I end up having to, every other year buy a second trumpet part, or those drummers, they're a bunch of slackers, so they're always losing their parts. So we're just constantly buying new parts. Is that a legitimate reason? I don't know. It certainly sounds like a legitimate reason from an educator standpoint. I don't know how much it would to a music publisher's, to a music publisher or to the court. Again, it's one of those things that it's impossible to say yes or no. Let me go ahead and mention this. This may be another question, but this is a question that's similar to that comes up a whole lot when I talk with music educators. What about a situation where a particular work is out of print? And those types of situations, in many cases, there's just no clear-cut answer. Assuming that the copyright, and it almost always is, it's still going to be a live copyright. how you go about making copies of that. Sometimes it's a situation where, you have tried to get permission, and you've tried to track down the owner, and, you kind of run up against a brick wall. There have been a couple instances relatively recently where Congress has attempted to put in place an orphaned copyright work scenario, and those have not come to fruition quite yet in copyright law. But forgive me for going down that road, but a lot of times people will ask that question. So the bottom line is it depends. In some cases, if it's a situation where you're simply trying to preserve that original and there's a legitimate reason, it may qualify as a fair use. The act of copying it itself, yeah, that's something you should not do. But again, it might be permissible under certain circumstances.
Thank you.
Yeah.
Let's jump to the other side. So we're talking about master recordings.
Okay.
Obviously, you were in the jazz program at Marshall. You took some of the courses there. You know, of course, that the history of this music is an oral history, and our texts are the master recordings in many senses. So in this new online environment where now many teachers have gone only online, but many were also incorporating, online listening and those types of things in their coursework already. Can we distribute? What's the best way to distribute or play for students a master recording on a class session, or in Blackboard, a learning management system? How can we do that appropriately so that we aren't skirting copyright requirements?
That's an extremely good question, and I'm just going to tell you straight up, I am not certain that I or anyone else at this point can answer it. Now, I feel very confident that after 2020, we will be able to find an answer to that pretty quickly, because we've kind of been forced into this. Here's my take on it. Okay, if we weren't if an educator was not using online virtual teaching environment, where would that education take place? In a classroom, right? So I think it's arguable that we're not changing anything virtually. If an educator was going to play a recording in the classroom, for criticism or education, whatever the purpose is, and assuming that it did qualify for, let's assume that it wasn't licensed for that purpose. Okay, let's assume that we're relying on fair use. If it would have been a fair use in a classroom that was, physical, face-to-face type classroom, why would there be a distinction, at least in a pure form, if we're still face-to-face, but it's via computer? Now, I've been practicing law long enough to know that anytime you get into transmission issues, it can bring up, it can take it outside of that box. Okay. And I'm not certain at this point if it's been challenged, if there are any ongoing cases. I don't do litigation anymore. I have an entirely transactional practice. I feel very safe in saying that we're going to see some of these issues fleshed out in 2020, or based on 2020, over the next couple of years. If not in the pure educational standpoint, then in church worship, and because that has moved online, and concerts, so many things have moved online. We're going to see, I think, a lot of these issues solidified.
So that answers the playing the recording in class. As far as sharing recordings, and you correct me if I'm wrong, I've always been advised that the safest way to do that is to share official links from a streaming service, because those versions are the licensed versions that are there on the service, rather than, say, going and grabbing my disc back here and ripping MP3s and posting them for my students.
Yeah. There again, it depends. You have to always go back and see. Obviously, you have to, don't assume that just because a work is being hosted on someone else's server, that's permissible. Okay. If there is truly license, if there is a license in place where it can be hosted and disseminated, distributed out from that server, that's one thing. If it's you just making that assumption and, well, hey, all I'm doing is just making it available by sending a link, if your link is permitting an infringement to happen, it's contributory there.
Sure. I was specifically mentioning like sending a link to a Spotify tune, like on one of the main services. Okay. Rather than like a YouTube link, which we don't necessarily know who's posting what on YouTube.
Exactly. But if we're talking about a link to where a Spotify subscriber can access that,
right.
That's one thing. Now, not to complicate the issue, but that's what lawyers do, of course. There have been, number of cases out over the years, particularly with blogging. It seems like that's where it came up with, potential liability just for providing a link. Believe it or not, yes, linking can lead to liability. So I always, if it's a situation like that, and particularly in an educational scenario where I think there's at least some general agreement that, there should be some leeway. I mean, look, the reason education is included in that preamble is to kind of set the stage. Again, it doesn't mean all educational purposes are going to be fair use. But if you reach out to a Spotify or whoever it is and say, hey, I'm an educator, I want to provide this. And if you can at least have something, even if it's just an email communication in your file that you have to, you can rely on, or an FAQ page or something, that's being proactive on your end.
All right, thanks.
So it's tempted to do it the official way.
Yeah. So this is another media-based question, and it's a question for our time right now. Obviously, in this COVID era, we see a lot of virtual performances popping up. And so the question is from Heidi, how do educational institutions deal with expensive sync license requirements in these days of virtual choirs, et cetera, that are only put up on YouTube for parents or friends to view? I guess the question is, right, we have rehearsed our students, and normally we would perform a concert.
Right.
And correct me if I'm wrong, but we have a right to perform that work at a concert because we purchased that work. Is that correct?
Depends on how the license is. So again, I always say go back to the license. In many cases, yes, that's the case.
However, and of course, as an educator, I've seen things. When you license, for example, a show from MTI, Musical Theater International, and you actually have to purchase a separate license to make a recording. And in those licenses, it actually states that it's one copy. You have to get another license if you want to distribute copies. And so I think the pertinent question here is, what are the legalities of recording, having students make a virtual performance recording of a copywritten musical piece? What would be required to put that video out and properly license and acknowledge the copyright holders? What would somebody have to do?
The kind of looking at it from a chicken or the egg standpoint, you kind of have first and foremost is you have to identify who owns the rights. Okay, and you really have to identify that. Let's assume that we're dealing with one music publisher. Let's assume we're talking about one song, just to keep it easy. Okay, one underlying musical composition that one single music publisher owns. Okay. You can go and really, that's the situation where you have to look at what is it that what rights are being implicated. Well, if we are making a recording, an audio recording, we're going to be talking about, for distribution, we're talking about a mechanical license. The fact that we're also talking about visual also brings up that display right. So we're talking, in fact, I think it was Heidi, I believe you said, asked about sync licensing. So yes, synchronization licensing is going to come in there as well. Now, here again, I think we're going to see is a lot of streamlining at least among the proactive music publishers out there. And I think you're going to see a lot of these processes, maybe not directly through or maybe not a direct license, but maybe through Harry Fox, but where you're able to get, all these rights, and acquire them. Now, from one stop instead of having to license each one separate. As it stands right now in 2020, I don't think we have enough enough instances where we can point and say, you need this, and this. I think you have to absolutely look and ask that threshold question: how am I going to be distributing this? If it's a situation where it's audio only, that's a little easier because we're talking about mechanical. We're talking about the right to record and distribute. If we're talking about bringing visual images in, which would be a pretty boring concert if you couldn't see the performance as well. That brings in those sync rights. So again, assuming that we're dealing with a single music publisher. Or a readily identifiable small number of publishers that have to grant those rights, that's the place to start and reach out to those publishers and ask them. I would be unbelievably surprised if you would find that a general pre-2020 license is going to cover you in this online sphere right now. It's things have changed, and again, I think that just given how things are moving, I think that we're probably heading there, but I don't think it's there right now.
So here's a general question, but it again pertains to these same, the streaming issue. And this is the most general version of this question. But obviously what's happening now, people take video of performances, public performances, whether it's in a concert at a school or it's outside or whatever. And those are performances of musical works that have copyrights that are held by other people. What copyright laws are violated when someone posts a live performance to Facebook or YouTube?
Yeah, that's a great question because you see it a lot in the concert realm because obviously it's easy. Who goes to well, not in 2020. Who in 2019 went to a concert and didn't have their phone with them? You can be posting while you're watching the show. It's interesting because you kind of have to think, divorce yourself from that particular situation and ask, what is it that I'm doing? If I'm recording, a musical artist performing, I am creating my own sound recording and my own video. Okay. So you kind of have to ask yourself, did I have the right to do that? Well, no. Okay. Well, then what rights are being implicated? We're not copying a sound recording, which again, the sound recording, there's no public performance right anyway, in that regard. But we are certainly implicating a performance of that underlying musical composition. Okay. So, it kind of goes back. It's very similar to that previous question. You kind of have to ask yourself, did this person have the right to, have a license to record it and post it? Probably not. Now, in fact, I would go out on a limb and say almost certainly not. Is it a situation where they're zoomed in on their daughter, their niece, their nephew, and yes, this music is there in the background? Is it something that is going to go in and have some impact on the overall value? Again, going through the whole 107 fair use questions, is it something that you're going to get a knock on the door from a process server where you're being sued for posting it? Don't know. The likelihood is low. Does that change the fact that you're using someone's rights without their permission? No. Again, that's one of those questions that lawyers get asked a lot, and we make a lot of folks upset because we can't really answer it squarely. Ultimately, the only thing we can say is there potential liability there? Yeah, absolutely. Now, if you're asking, is there potential liability for the school? If it's a parent who posts it, I don't know. Probably not. But the bottom line is lawyers are good at suing everyone and letting the courts figure out who it is that ultimately is responsible for it.
So what happens if the shoe is on the other foot? If you discover that your work was put on YouTube or streamed and you do want to file a claim, can you talk about a little bit about what you would tell a person to do in that case?
The facts are always going to be different. I mean, the bottom line is, under the DMCA, Digital Millennium Copyright Act, you have, the ability to go in and provide a takedown notice, to an ISP, to an internet service provider. And there are, if you go on any platform, you're going to find the information for the designated agent at that ISP that you can send that to. If you are the owner of that copyright, you can send that notice and take it down. I mean, that's the reason, if you go in and look on YouTube, for a particular recording, sometimes you'll see this, this material has been removed, It's probably because they received a DMCA takedown notice from the copyright owner. But again, I won't bore you with all the details of DMCA, but there again, it's a trade-off. The DMCA provides a safe harbor provision, so that those internet service providers can't be sued as long as they provided that mechanism, so that the copyright owner could say, hey, someone posted this and it's infringing on my on my work, on my copyright, and there's an affirmative duty to take that down, assuming it matches up with all the requirements under the law. All
right, you got time for one more?
One more. Yeah.
All right, cool. Thank you. So this is a question. It's kind of a few layers. So if you wouldn't mind, I'll walk you through it. So I'm a musician. I want to make an album. I've got a bunch of original compositions, my own compositions. I am not, I don't need to get any mechanicals. I'm not recording anyone else's works. Okay. Should I register the underlying compositions?
If you are putting, and again, this isn't legal advice, but generally speaking, in that situation where if you are getting ready to put your music out there, you're going to distribute it. Yeah, I mean, when you put out your album, you are publishing not only those sound recordings, but you are publishing those underlying musical compositions. Again, we're talking about two copyrights, both being simultaneously published. Assuming you've never recorded them or used them before, that they've never been published before, or haven't
published them as a collection of sheet music, for example.
Exactly. They've never been published in any way, never been registered. There's a very practical reason for doing that. There are certain rights. Kind of going back to what I mentioned about registration not being required. Registration is not required, but registration, is it's a jurisdictional requirement before you can sue someone for infringement. Another issue that kind of dovetails with that being the key to the courthouse is the fact that if you make a timely registration, and a timely registration is within 3 months of initial publication, you can avail yourself. Doesn't mean you're going to get it, but you can ask for a recovery of statutory damages, which means you don't necessarily have to prove. You don't have to prove how much you were damaged. Okay, you don't in order to get a certain enhanced amount. The other thing is it opens the doors to you recovering your attorney's fees. I'm not going to sugarcoat it. There is no such thing as inexpensive litigation, but copyright litigation is particularly expensive. Okay, all litigation is expensive. Copyright litigation is really expensive, and if you are able to get, assuming that you prevail and are successful in your claim, if you can have the other party pay for your legal fees, that's definitely a benefit. So just for those reasons alone, it makes sense to register those underlying musical compositions.
All right. Thank you so much, Kevin, for spending some time with us today.
Yeah.
We are going to follow up this session with another session in the future where hopefully we can dive a little bit deeper into specific issues and questions, even some more specific issues and specific questions that our members and audience may have. But for now, we're going to say goodbye to Kevin and let him go. Thank you, Kevin. And don't forget, if you are not a Gen member, please head on over to our website. It's right there on the screen, jazzednet.org. And you can join now, pay later with the code JOIN20NOW. If you are already a member, you can renew now, pay later with the code RENEW20NOW. We hope you've enjoyed Copyright 101 for music educators, and we will see you soon on the next Gen webinar. Take care, everybody.